Is it possible to dispose of the check bounce cases within 6 months? Yes, it is possible to dispose of the check bounce cases within 6 months. But then why is the judiciary taking about 25 to 30 years for their final disposal? It is only due to lack of will to ensure justice in time by streamlining the procedures and strictly complying with the statutory provisions in true letter and spirit. Check bounce cases are dealt under the Negotiable Instruments Act. There are only two simple issues to be decided in these cases, that is whether the check was issued by the accused, and if so, whether he is liable to pay the said check amount. As per subsection 2 of section 143, the trial for offence should be conducted on a day-to-day basis and as per subsection 3 of section 143. The trial should be concluded within 6 months from the date of filing of the complaint. But these statutory provisions are completely ignored and violated by the trial courts and appellate courts, causing avoidable inordinate delay in their disposal. That's why cheaters lost fear about the judiciary and are intentionally evading payments and getting pecuniary advantage at the cost of the complainants. Following are some of the deficiencies for denial of justice by delaying it. 1. Periodical directives from superior courts to accord priority to old cases, say more than 5 years old, are wrongly misunderstood and inferred by the magistrates that they need not take up the cases seriously till they become 5 years old and the cases are listed only for record's sake and adjourned for long months with no valid reasons. 2. The Limitation Act is applicable only to the litigants but not to the judicial authorities. So they take their own sweet time in their duties and responsibilities and try to defend the delay by showing the pendency of the cases. 3. Complainant is not deemed as a victim in check bounce cases. Hence the magistrates infer the accused as victim and the entire proceedings are conducted with such wrong inference only and they are more sympathetic and liberal to the accused. 4. The accused on conviction may appeal to the same district court, but the complainant has to appeal to the High Court on dismissal. 5. The appellate courts never take into consideration the time spent in the trial courts for the purpose of seniority and treat them on par with the other cases having original jurisdiction with them, completely violating the provisions of NI Act. 6. If the appellate courts hear the arguments on the merits and demerits of the cases immediately after they are registered, they can be disposed of within a very short time. But there are several instances where the time spent in the appellate courts are 2 or 3 times more than that of the trial courts with no reason. 7. The accused, to evade the payment due to the complainant, always tries to delay the disposal of the case on various flimsy grounds and irrelevant objections. Magistrates also consider all such objections and adjourn the cases frequently by going into unnecessary technicalities. 8. Some magistrates even become hyper-technical and dismiss the cases without taking into consideration the merits of the cases. 9. There are several cases which are dismissed due to incompetency, bias of magistrates, or incompetency, collusion of advocates. In such situations, The apex court directive that the Court of Appeal should be circumspect in overturning the judgment of acquittal is openly influencing the appellate courts to become biased, which is not expected from the judiciary. That's why some courts are not even listing the acquittal cases for long years, causing irrecoverable loss and damage to the complainants. 10. The opportunity to appeal to too many courts for simple issues, and every court taking more than 5 years, even more shows that judiciary publicly accepts the incompetence of its judges. Besides delaying justice for 25 to 30 years. Hence only one chance to appeal should be allowed for ensuring justice in time. There is no need to form any high-level committee and seek its suggestions etc. for early disposal of cases. Judiciary should ensure that the trial courts and appellate courts should strictly comply with the existing statutory provisions of subsections 2 and 3 of Section 143 of NI Act for justice in time. Then miracles will take place automatically in timely disposal of cases, and the cases being registered every year also will be reduced drastically. Comments and suggestions, if any, may be offered in the comments column and also emailed to lokkalyan999@yahoo.com and sent to mobile number 9603099900. This video may be widely circulated for creating awareness to the public.